Oh, what's going on, everybody? It's your Uncle EJ, always your mother's brother and your grandmother's good-looking son. Oh, Norbes versus URL. I told y'all my last couple of blogs, battle rap is growing up. I know they only been doing YouTube and all that for battle rap since 2009, but battle rap has turned 21, or shall we say 18, because now it is legally responsible. Now there's a lot of money moving around here. I hear a whole lot of people saying on a bunch of these different lawsuit breakdowns, Norbes, get out of here. No way. No way it could happen. I even see people who have the lawsuit because it's public record. They say there's no way that could happen. Did they break this thing down right? Because that ain't what I read, bro. But first, if you really want to know how big battle rap is, what we have here is Business Wire. Business Wire is a Berkshire Hathaway company. What and who is Berkshire Hathaway? Berkshire Hathaway is one of the highest traded stocks on the New York Stock Exchange, and it's owned by a man by the name of Warren Buffett. So, think we ain't talking big time no more? Think we ain't talking money no more? Think it can't happen no more? Check it out. Ultimate Rap League sued by co-founder Dagoberto Velez for $40 million. Executive alleges he was wrongfully forced out after lucrative deal signed with Drake and Caffeine. New York. Co-founder of the Ultimate Rap League, Dagoberto Velez, Norbes, recently filed a $40 million lawsuit against Ultimate Rap League, alleging he was wrongfully pushed out of the battle rap company after it signed a lucrative deal with world-renowned recording artist Drake and social broadcasting platform Caffeine. Velez, who helped build URLs, among other things, is a primary talent recruiter, filed the multi-court lawsuit against URL executives Troy Mitchell, Eric Beasley, and John French, alleging breach of contract, wrongful dissolution, negligent misrepresentation, breach of fiduciary duty, and unjust enrichment, among other counts. Velez is represented by attorneys Jamar Creech of Diversified Law Group, Landon White, and Martinez Jackson. According to the lawsuit, Velez co-founded URL in 2009 and has since been responsible for identifying and securing most of the talent that appeared on the company's many online rap battles. The lawsuit states that Velez had authority to bind the company to contracts and engage in negotiations. He often appeared on camera to represent the URL, and his image and likeness often appeared on advertisements. The lawsuit explains that Velez was an integral part of developing URL into, quote unquote, the world's most respected MC battle arena. And defendants Mitchell, Beasley, and French have made admissions that Velez is a partner or joint venture of the company. In February 2020, URL announced a partnership with Drake and Caffeine to supply rap content on Caffeine's social broadcasting platform. On April 28, 2020, the defendants publicly, quote unquote, dissolved their relationship with Velez. On July 1st, 2020, Caffeine announced that it had raised $113 million in a Series D round of funding, and that battle rap will be its quote unquote anchor content, and highlighted its relationship with URL. The lawsuit states that Velez was a significant contributor to URL, helping it get exposure on national television and contributing to the landing of the company's deal with Caffeine Incorporated. Velez seeks more than $40 million in damages, as well as 10% royalty in perpetuity from the URL. The lawsuit is available here at www.lawsuitpressrelease.com. So, what about the lawsuit, EJ? What about the lawsuit? Let's see. Because, I mean, I'm telling you, Hollow the Don is saying it now. You guys are going to have to go get represented because it's a whole lot of money at stake now. It's not just $1,000. It's a whole lot of money at stake. What I want you to realize is that this document is filed in New York County Clerk, September 10th, 2020, 647. It's in there. Jurisdiction and venue, Supreme Court of the State of New York. Supreme Court of the State of New York. Because of the amount of money, has to go to Supreme Court and not smaller civil court. In 2009, plaintiff was approached by defendants to be a partner and to form what would become the Ultimate Rap League. Plaintiff Velez, defendant Troy Mitchell, defendant Eric Beasley, and defendant John French agreed that the plaintiff's pivotal role in the partnership was to create the structure for the Ultimate Rap League. On or about October 26, 2009, the Ultimate Rap League began its operations as a New York general partnership with Troy Mitchell, John French, Eric Beasley, and Dagoberto Velez as partners, aka Norbes. The purpose of this Ultimate Rap League was to conduct a cappella rap battles targeting the urban culture and hip-hop music genre through live events. The battles were then uploaded to the company's YouTube channel to reach a worldwide audience, right? So basically, it says from 2009 to 2020, plaintiff as a partner executed many activities that were included but were not limited to the following: recruiting talent, on-screen and supporting staff, engaging in promotions, hosting battle rap events, organizing battle rap events, executing contracts, raising capital, and developing business concepts for the Ultimate Rap League. From 2009 to the present, the Ultimate Rap League has featured the talent that plaintiff has secured to perform for the company at its live events and on digital platforms. From 2009 to the present, the Ultimate Rap League has not held a single battle rap event without any of the talent acquired by plaintiff. The events detailed in this complaint are some of the events held by the Ultimate Rap League from 2009 to present. And this starts from point 22 and probably goes all the way, I believe I read it, and it goes down to about 259. And it's basically outlining all of the events that Norbes was part of or put on. Let's see, there's one particular part I want to show you. Here it is. Section 254. Plaintiff brought the following talent to the Ultimate Rap League, all of whom currently average over 1 million views on the YouTube platform for their battles, according to the online Battle Rap Index Verse Tracker. Sue Surf, Holla the Don, Hitman Holla, Calico, Tay Rock. Plaintiff was also responsible for bringing the following talent to the Ultimate Rap League: Conceited, Big T, Cortez, DNA, Old Red, Shotgun Suge, John the Don, B Magic, Bill Collector, Clean Paper, Averb, Young Ill, JC, Av, Emerson Kennedy, Jerry West, Ill Will, Big K, Chilla Jones, T-Top, Briz Rothstein, Chess, The Saga, Prep, Geechee Gotti, New Jersey Twerk, Rosenberg Raw, Jazz the Rap, Big Cannon, Danny Myers, Don Marino, Jay the Nightwing, Real Sick, Snow, Fonz, Mike P, Chef Trez, Ryder, Young Cannon, Prez Mafia, Swamp, Gunpowder Pat, and Steams. This is not an exhaustive list of all the talent that plaintiff brought to the Ultimate Rap League. So in the lawsuits, it says that they've thrown over 200 events and that there has been no events that have not used at least one person that Norbes has helped bring into the URL. Plaintiff is a significant contributor to the Ultimate Rap League, reaching over 1 million subscribers on YouTube, getting exposure on national television, and landing its deal with Caffeine. Plaintiff never received a contract in writing for the plethora of services that he was providing to the Ultimate Rap League, or a written employment agreement from the Ultimate Rap League. Plaintiff often appeared on camera to represent the Ultimate Rap League on various media platforms. Plaintiff's image and likeness often appeared on advertisements and videos for the Ultimate Rap League. Plaintiff never received notice that the Ultimate Rap League was changing its entity structure from a general partnership to a limited liability company and vice versa. Plaintiff had the actual authority to bind the Ultimate Rap League to contracts and to engage in negotiations for various business opportunities. None of this sounds like contractor work to me. Plaintiff, with the knowledge and consent of the Ultimate Rap League, used his bank accounts to pay for expenses of the Ultimate Rap League. Plaintiffs and defendants Troy Mitchell, Eric Beasley, John French verbally agreed to be partners of the Ultimate Rap League. Plaintiff was not the custodian of the financial records of the Ultimate Rap League. Plaintiff's name and likeness continue to appear in many videos currently on YouTube, on the official Ultimate Rap League channel, and other digital media platforms. Plaintiff is an integral part of developing the Ultimate Rap League into becoming the world's most respected MC battle arena. Now, that's the short version without me going through the 259 other different instances where Norbes either had text messages, email, all of the battlers, the events that he did, back and forth, all of that. What I really want to focus on is how people were saying that there's no way that it's possible that Norbes could own the URL after all this. I'm debunking that. Because I'm not saying who will win either way. I'm saying what could happen if Norbes wins. What could happen if Norbes wins? I want to find count one, wrongful dissolution. And dissolution is basically if me, you, and somebody else have a partnership together, and me and partner B decide that we're going to cut partner C out and dissolve the partnership without the consent of partner C. That's a wrongful dissolution. Right. Plaintiffs adopt a reference to the allegations contained in paragraphs 1 through 69 of this complaint with the same effect as if herein fully set forth. Between approximately October 26, 2009 and April 28, 2020, defendants have made admissions that plaintiff is a partner or joint venturer of the Ultimate Rap League. Plaintiff received notice that he was no longer part of the Ultimate Rap League partner or joint ventureship via a statement released from defendant Ultimate Rap League. Now, y'all stay with me. Don't tune away. I'm going to get to the part to where Norbes could own all this shit. I'm telling you, y'all got this paperwork fucked up. Let me see. Defendants did not pay plaintiff in cash the net amount due to plaintiff from the partnership or joint venture minus plaintiff's liabilities. Defendants did not provide plaintiff of an accounting of the business or any type of audit before making the statement that plaintiff was in no way involved with the Ultimate Rap League. As a result, the wrongful dissolution, plaintiff is now entitled to enforce payment from defendants and rights to the partnership or joint venture property via dissolution and winding up. Remember those two words, via dissolution and winding up, and why they are going to be very relevant in what I say in just a couple of minutes. Dissolution and winding up. Count two, misrepresentation. Plaintiff adopts a reference to the allegations contained in paragraphs 1 through 277 of this complaint with the same effect as if herein fully set forth. Defendants raised false statements to third parties that plaintiff was fired as an employee and no longer involved in doing business on behalf of the Ultimate Rap League. Defendants knew at no time since the start of the Ultimate Rap League in 2009 did the partners ever represent plaintiff as anything but a partner in the URL. Over more than a decade with the Ultimate Rap League, defendants never represented an IR. Here's a good point. Check this out. Over more than a decade with the Ultimate Rap League, defendants never presented an IRS Form W-2 or an IRS Form 1099 to plaintiffs. Most of you, not all of you, have been employees before of a company. On your first day of orientation or whenever you fill out paperwork, they make you fill out a W-2. What is this W-2 for? So the employer can withhold your Social Security and federal tax benefits, or state as well, from your paycheck, right? If you are not an employee, you get issued a 1099 at the end of every year, or at the before the ending of January, I believe. You receive a 1099. That 1099 is a document that says that you were a contractor and not an employee, and you are thusly responsible for all taxes that are owed for that money, right? So if you're an employee of a company, you're either going to get a W-2 as a legitimate employee signed to the company or an employee by the company, or if you're a contractor, you will get a 1099 because Uncle Sam says someone is going to pay taxes on this money. So Norbes is saying he's never filled out a W-2 and never filled out a 1099. So if he hasn't filled out a W-2 with URL, how could he be an employee? And if he's never filled out a 1099, how could he be a contractor? Okay, let's keep going. Defendant statements were made by defendants with the sole purpose of defrauding plaintiffs. Defendants used the platform to spread the fraudulent statements, left plaintiff with no choice but to rely on the statements. Defendants' actions have caused plaintiff to be financially and emotionally damaged because of defendants' statements. Wherefore, plaintiff alleged demand judgment against defendants in the amount to exceed $500,000 with interest and costs, as well as any recovery the honorable court sees fit. And here is the coup de grace. Coup de grace. I don't even have to read none of this other stuff. None of the money even matters. The money does not even matter. I don't care if it's $4, $40, 400, 400,000, 40 million. The money doesn't matter. Here's what matters. If they had a partnership, if the other partners dissolved the partnership behind the back of another party, of the other party, right? Okay, let's read. Further, Plaintiff requests that the court force a winding up of the partnership and declare that plaintiff is the sole owner of the business under New York Partnership Law 63 and 68. Now, people are going to be like, yo, all this is alleged, EJ. It's alleged. It's alleged. Yes, it is alleged. Let's talk about what we see on our own, before our very eyes. Let's not play. Let's not play. No, you've never seen any paperwork that has Norbes' name on it as far as associated with the URL. But we all know for the last 11 years when Norbes showed up, that was the same thing as a URL showing up. Ain't this what we watched? Ain't nobody got to tell us, no, this is what we watched, right? There's over 20 videos that in some reference or some form point to Norbes being more than a contractor or an employee of the URL. This is besides the paperwork, the volume of paperwork and receipts that Norbes has kept on the whole thing. So you ask, what is New York Partnership Law and what is Article 63 and 68? Well, because I have nothing better to do and I've been drinking coffee at 11:30 tonight, I looked it up. So let's talk about that. We're going to start with Section 63 first. For you wonderful educated people who know so much that you decided that Norbes could not own all this shit at the end of it. And I know some of you big bloggers going to look, then you're going to go look it up for yourself and you're going to decide it was your big idea. Do your thug thizzle way gangster. Anyway, the court shall decree a dissolution. 1, on application by or for a partner whenever, not sometimes, whenever, a partner has been declared incompetent in any judicial proceeding or is shown to be of unsound mind. That's not the case here. B, a partner becomes in any other way incapable of performing his part of the partnership contract that may be in question here. C, a partner has been guilty of such conduct as tends to affect prejudicially, whatever, the carrying on of the business. Prejudicially. I just really want to say that word right. Anyway, prejudicially, how about that? The carrying on of the business. A partner, or indeed, a partner willfully or persistently commits a breach of the partnership agreement or otherwise so conducts himself in matters relating to the partnership business that is not reasonably practicable to carry on the business in partnership with him. E, the business of the partnership can only be carried on at a loss. F, other circumstances render a dissolution equitable. So D, a partner willfully, persistently commits a breach of partnership. So let's say allegedly and hypothetically, Beasley, Chico, Smack, and Norbes are in a partnership, right? Hypothetically, just for saying. Partner B, C, and D decide that they're going to start their own company without partner A, but still use the intellectual property that they have learned together and done business together. That's a breach of the partnership. That's a breach of the partnership. We're not even talking about money yet. That's a breach of the partnership. That's a breach of the partnership, right? Okay. And it also says that it's reasonably practicable to carry on the business in partnership with them. So do you really think that if the judge said, you know what, Norbes, you are a partner and y'all are partners and y'all need to get back together, you think they could work together? Hell no. So at that point, you have a problem. You have someone who owns part of a company and others who own part of a company that now can't work together and be amicable. So they dissolve the company, split the money. So what happens if they sell and split the money? If allegedly URL is found to have been fraudulent or breached their partnership with Norbes, if they've been found to defame Norbes, if all of this happens and they lose the lawsuit, the company gets dissolved. And if it doesn't get dissolved, you know what happens? That's where the term winding up comes in. Well, what happens when you wind it up, EJ? Let's see. Section 68, the right to wind up partnership. Unless otherwise agreed, the partners who have not wrongfully dissolved the partnership, the partners who have not wrongfully dissolved the partnership. So that means the person who would win the case. So let's just allegedly speak in terms of Norbes. Unless otherwise agreed, the partners who have not wrongfully dissolved the partnership or the legal representative of the last surviving partner not bankrupt has the right to wind up the partnership affairs, provided, however, that any partner, his legal representative, or his assignee, upon cause shown, may obtain winding up by the court. Which means that once they've allegedly been found to been breaching their contract with Norbes, Norbes is the last man standing. He gets to wind up all the business affairs of URL when the court dissolves it, unless otherwise agreed. So how do you stop all this? Best bet, don't go to court, URL. Y'all need to come up with a settlement, URL. I'm telling you, because you go to court, sir, and you lose, it ain't even about the money. If he just proves that y'all breached the contract, they might dissolve the URL. If they dissolve the URL, you can't use that name or that branding anymore. It goes to the person who winds it up. Norbes. So now y'all think it's just, you think it's a fantasy now? You think it's a fantasy now? If you look in these documents too, you realize, just like I told y'all in that other blog, that over the 4th of July weekend, Smack wasn't excited to introduce those battles. That's because on July 1st, he got served with a certified letter that he never responded to in 2 weeks. So then they sent out something else saying that they wanted their money. And Smack and Chico and Beasley responded that Norbes was a contractor. And so then, with no other means necessary to get his money, they're saying that I'm not a partner after I've been a partner and helped build all this stuff and brought 80% of the talent. This is all alleged. There's no other recourse to get my money than to sue them. Yep. Buckle up your shoes. Put your good pair of pants on, battle rap, because y'all finna make some big boy decisions. Y'all finna make some big boy decisions. And y'all thought that 40 million was a crazy number. It wouldn't matter if the number was $1. If they get found to be in breach of the contract, they could dissolve the whole thing. Or Norbes could be the last man standing. Read it. Read it and I got one more. Y'all remember this? URL dissolves relationship with Norbes. There's that word again. There's that word. Like when you fire somebody, you've never gotten dissolved from a job. Did you get fired? Did you get laid off? You get furloughed? You never got dissolved from a job. You know what happens in law? What gets dissolved? Businesses, partnerships. But I digress. The Ultimate Rap League, the premier destination for battle rap programming, announces the culmination of its over decade-long relationship with Divalez, aka Street Star Norbes, effective immediately. While we have enjoyed the time of our professional engagement with Norbes, the new decade has brought forth many changes that do not afford the team allowances to continue with some of the relationships we have had in the past. The decision to discontinue at this time a professional relationship with Norbes is a consensus that our team unanimously agreed upon. Unanimously. Y'all released that statement and said y'all were not messing with Norbes no more. That y'all were dissolving your relationship, a business relationship. Because, Smack said it's about business. Now I'm saying that it says that in the lawsuit. That's the only reason I say it says it's about business. Now I'm saying they actually quoted. Now I'm saying in the lawsuit. That's crazy. Going forward, as URL restructures how we scout new and emerging talent, all submissions and inquiries should be sent to the current official URL staff. To the current official URL staff. To review for replacement or inclusion. URL, you got some explaining to do. You got some explaining to do. I don't care what nobody say. I don't care what no jailhouse lawyers say and none of that. I can read it for myself. Yep. There's over 300 counts of different stuff. And then there's about 7 or 8, 10 counts of at least 20 videos by my count where they said that Norbes was an integral part. So it doesn't matter at this point whether you think he's worth 2% of the company, 5%, 10, 20, 40, 90. If his partners are in breach of contract, they could dissolve the whole thing. And if they don't dissolve it and Norbes winds it up, it can end up being Norbes Rap League. Anyway, Shonker EJ always. I'm just trying to keep it objective and fair. I don't be. If you take your time and just read some of this stuff, man, just don't take people's word for it. Read it for yourself. When people tell you Norbes could be something, don't just go, no way, hell no, fuck no, he doesn't deserve it. What do you deserve after your partners cheat you? Not saying that Smack Beasley and Chico cheated him. This is all alleged. I'm just saying, what do you deserve if your business partners cheat you? Do you deserve to come back in the company and y'all work all together again? Or do y'all need to sell the company, and get your money for it. Anyway, it's been your Uncle EJ always. Y'all holler at your boy.
EJ, always. EJ, always. EJ, always. EJ, always. EJ, always. Representing that wave gang. EJ, always. EJ, always. EJ, always.
You are now rocking with
DJ Ladybug.
On the ones and twos, and just call me Monty on everything. Y'all know what it is.